Start. This petition has been filed seeking to invoke the jurisdiction of this court under Section 14 and Section 15 of the Arbitration and Conciliation Act, 1996 full stop. Essentially, the petitioners request this court to interfere mid-course, when arbitration proceedings are underway, full stop. The petitioners filed an application before the learned arbitrator, calling upon him to recuse from the proceedings on the ground of his impartiality and independence being allegedly suspect. Full stop. The learned arbitrator has refused to do so, by an order dated October 28, 2024, which is challenged in this petition. For this petition to be considered, the petitioners ought to make out a case that there is a de jure inability on the part of the learned arbitrator to perform his functions, full stop. Without that threshold being met, the petition cannot be entertained, full stop. For the reasons set out in this judgment, the petition is dismissed, full stop. Para. A brief overview of the factual matrix involved in the matter at hand, would be instructive, full stop. According to the petitioners, the arbitrator did not make the disclosure mandated under Section 12(1) of the Act, full stop. Petitioner number 1 is the principal borrower of loans from respondent number 1, which is a multi-state cooperative bank, full stop. Petitioner number 2 to 4 are guarantors of the borrowings effected by petitioner number 1, full stop. The arbitration proceedings have been initiated under Section 84 of the Multi-State Cooperative Societies Act 2002, full stop. The petitioners allege that the learned arbitrator made a disclosure with a delay of 9 months, and that too only after they sought it, full stop, on the basis of the disclosure, which they claim to have received only in October 2024, they filed a challenge before the arbitral tribunal, full stop. Para. The disclosure made by the learned arbitrator is found at Exhibit C to the petition and is dated January 20, 2024, full stop. Under Section 84(4) of the MSCS Act, it is the Commissioner for Cooperation and Registrar of Cooperative Societies who appoints arbitrators when a reference is made by any cooperative bank, full stop. The appointment being made by the statutory authority, it is not the cooperative bank that makes the appointment, full stop. Para. Typically, when loan assets of a cooperative bank become non-performing assets, the banks report the same to the registrar, who makes the appointment of an arbitrator for various sets of loans, full stop. By a order dated May 27, 2024, the registrar appointed the learned sole arbitrator who is conducting the proceedings now, and about whom allegations are being made by the petitioners, full stop. Annexed to that order is a list of cases pending with the learned arbitrator and new cases referred to him, full stop, that forms the basis of the allegations levelled by the petitioners, full stop. The petitioners filed an application dated October 22, 2024 before the arbitral tribunal purporting to invoke Section 14 of the Act, full stop. However, such application is referable only to Section 13 read with Section 12 of the Act, full stop. It is this court that has jurisdiction under section 14, while the jurisdiction in the first instance is before the learned arbitrator under section 13 of the Act, full stop. For all purposes of this judgment, the petitioner's application to the learned arbitrator is referred to as the section 13 application. Stop.